All right, hello and welcome everyone. We're going to get started now. All right, so welcome to the Family Law Now live virtual event series. Thank you for joining us today for Beyond Adversarial and Toward Amicable, How One Lawyer Can Help Both Spouses Separate Together. This event has been accredited with 1 hour of professionalism. Today, the panel will explore the growing gap between what amicable separating families are asking for and the adversarial structure that continues to dominate family law practice. Using the one lawyer divorce method as a concrete Canadian case study of how a non-adversarial model has been developed, tested, and regulated in response to the gap, and how a one lawyer style of legal practice can make divorce kinder, quicker, and easier. As always, we encourage you to participate in the polls and use the Q&A feature throughout the event. All the resources mentioned today will be included in the show notes, which you will receive via email later this week. I will now introduce our panelists. Melissa Bourgeois is a practicing family lawyer and the founder of One Family Law. She is the creator of Canada's first one lawyer divorce method, a neutral, client-centered process that allows one family lawyer to guide both spouses through their legal separation together from start to finish. Melissa's work focuses on delivering non-adversarial legal processes for amicable families and on how family law can responsibly evolve to meet the needs of separating couples who are seeking alternatives to traditional adversarial approaches. Golan Yaron is a senior family lawyer and a certified mediator with over 30 years of legal experience. He was first called to the Bar of Israel in 1996 and then called to the Bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiating agreements, as well as trial work. He also has experience in negotiating with authorities to advance clients' interests and has represented clients at various levels of court. Deepti Sharma is an Alberta family lawyer and litigation associate known for her strategic, data-driven approach. She was called to the bar in 2001 in Alberta. Combining an MBA and statistics background with 6 years experience in Fortune 500 HR, she specializes in high-conflict parenting and financial matters. Deepti is a versatile advocate, appearing at all levels of court while maintaining a strong collaborative and mediation-based practice. I will now hand things over to our speakers to get started with the presentation.
Thank you, Jen, for having us. As the new kid at the firm, I'm mostly just thrilled to be slotted between Golan and Melissa. They're basically the legends of the field. So I'll be taking plenty of notes today, and I'm definitely going to be picking their brains from time to time, mostly because I want to see how the experts do it. The families that we're seeing now, there's definitely a cultural shift towards emotional intelligence. The clients are modern. They are moving away from a bulldog advocacy in favor of a quiet resolution mindset. We all have experienced the family law landscape in 2026 that has transitioned from a more battlefield approach to a more complex administrative role. I believe that today's sophisticated clients are often self-informed. They're using AI tools to research procedural timelines. They're organizing their disclosures before even they're meeting with their lawyer for the first time. They don't want exhaustive case law memos. They just want a navigator to translate the statutes into clear, actionable figures, and they want to see predictable next steps. In terms of the efficiency and reasonableness, I believe that there is a marked preference for neutrality and fairness. So the clients not only want a positive outcome for themselves, but they're very, very cognizant of the fact that they also want a fair outcome for their ex-spouses or ex-partners now. So they're preferring this approach over traditional winning. There's definitely an approach where the clients that I have come across so far, even in my initial consults, they want proposals that align with what a justice would find acceptable, so that they're open to reality checks. They are open to boundaries again, because they want those plans which are more futuristic, where the friction is reduced for both sides in future. The clients are focused on procedural speed, and they don't want that there should be unprecedented delay because of court processes. So they they don't hesitate, in my experience so far, to be involved in every step of the way, which was probably not the case in the past. And before I move on, Golan, I'm very curious because you might have likely seen this play out in 100 different ways. And I'm being a wide-eyed optimistic about these amicable doctors and engineers that are coming to the lawyers now. Are you seeing this shift towards predictability?
Well, firstly, thank you, Deepti, for the question. Let me start with a whether there is a shift or not. It's really hard to say. There are some rules in place that requires and expectations, including the rules by the Law Society that requires us to uh, try and mediate and advance a less adversarial model of conflict. Um, I myself have experienced the shift over the years. I've been doing this for a long time. So starting with a very adversarial and in fact, perhaps the only method that was out there decades ago. And then with the mediation always being somewhere in the background for those who were more amicable to try and facilitate the resolution out of court. So there is definitely a shift, but the shift is what's motivating the shift is more, I believe, is financial. It's the inability of many to afford the adversarial model, the traditional one that requires ongoing court proceedings, and it just cannot keep up with the mounting legal fees. Obviously, some are motivated by just looking to move on and wrap up and have closure on things. And this now has become more and more available, and parties or people that are involved in the separation or going through the separation are, like you said, Deepti, are educating themselves about what methods are currently available. So it's easily accessible online, through internet, looking at AI. All of these tools are now available for the more tech savvy, I should say, but we still have those who are not as tech savvy, or that, old timers, and those who have been out of the technology field most of their lives, are not up to date or up to speed with things, and they still, looking at ways to um, resolve matters, and the only thing that they may know of is going to court, right? Because that's what was available when they started the relationship. You would find that many of them did not have a prenuptial agreement or the domestic contract. We're talking about those that have been married for 20, 30, 40 years, and all of a sudden there's a breakdown of the relationship. And so it's depending on the generation, depending
Yeah.
on the education level, sophistication, all of that can drive the separating spouses from the traditional adversarial system towards a more workable and less expensive uh, collaborative system that can, help the families as a whole.
Sure. Thank you so much, Golan. That definitely puts some light over the fact that people are kind of mixed in their approach. And I definitely agree that the long-term marriages that are being dissolved right now, people separating, they have a different approach. And while the modern client might be able to kind of research and go to AI to get some answers, but they still have the gap where they don't know what the judicial temperament looks like. So there's definitely a lot of scope for lawyers to fill those gaps. And I guess today's clients, I'm talking about the modern ones, which are like more tech savvy. I think they're intuitively also inclined in a certain way that while they might not know what a principled negotiation approach would be, they're still able to separate in a certain way people from the problem. So they want quick resolutions. They understand that the court might be a long drawn out process, and they want to prioritize moving on or their interests, and they are worried about both the sides, whether it's a long-term marriage or short-term. There is a shift, like people don't want to just win over the ex-spouse or the partner. They are willing to kind of look at creative possibilities where they're exploring a variety of solutions that would fit both the legal framework and the unique personal circumstances. So I think there's definitely a clear shift towards accepting results which are based on objective criteria and not just lopsided in their favor. So there's that shift that I have kind of seen in my limited experience that I've had so far. And I'm just a new person here, so maybe I'm oversimplifying this. Melissa, in your legendary experience, what's that one thing that usually trips up a simple, amicable settlement?
Yeah, so all of this is just so wonderful to participate in. And so thank you, Deepti, for, introducing us and kind of getting this started. And what it is really is this shift of people, they have more access to information than they've ever had, but they still want lawyers, the professional involved in this. And so, my process was kind of, developed in response to what I view to be more vulnerable people in the subsect, who are the amicable couples who relatively get along, and that were bypassing lawyers because they thought lawyers are, okay, well, these lawyers are going to breed conflict where there was none, or different things like that. So really kind of the changing landscape, I think that all three of us have been speaking to, is driven by the clients themselves and what their needs have been in changing, evolving over time. So less rights-based, my own rights, my own things, asserting my dominance over you in that legal setting, to cooperative, kind of how are we going to work together to solve these legal issues that we have, and can we do that with, a shared professional? Because that was the hunger that I was seeing, is these people still do want lawyers, and I think we're very important. We continue to hold a very important role in society. So I just wanted to kind of advance that thinking in this way.
Yeah, sure. Thank you so much. Jen, are we headed to our first poll question then?
Yes, it should be up on the screen now.
Jen, for some reason, I cannot see the poll results. Can you just let us know how does the poll look like?
Sure. I think it's still open.
Okay.
Oh, the poll's done. Oh, here we go. Okay, so the number one answer was the power imbalance fear, worrying what a nicer process lets the dominant spouse win. Our second most popular answer was the full disclosure risk. Number two was the settlement burnout. And then number four was financial loss.
Sure. And I think there is definitely personality types in this, which can significantly affect the process, because obviously people have different approaches to this, and especially when there is a high conflict hijacker, for example, in this situation, then in that case, it's very likely that the person who's ready to concede might give a lot more than they would want to, because they just want to probably get over with this, or somebody else is able to hijack the entire situation to their advantage. So that's where the professionals probably can help. The lawyer's job would be to ensure that consensual does not mean uninformed. They have to guard against the settlement that are reached simply to escape admin delays. They have to keep a check whether there is a high conflict hijacker in the situation. And again, there can be some practical fails which can result in clients paying for both a failed mediation and subsequent litigation, which then in case would double the financial and emotional burden, as the poll suggests. But I would leave it open to Melissa and Golan to add to what our poll results reflect.
Yes, I can start by saying, looking at the first inhibitor, the fact that people are thinking that the power imbalance is one of their biggest hurdle in moving this forward towards a more amicable model of resolution is reflecting of the fact that even professionals are still not familiar with the process. The fact that when we are advising or inviting parties to use this non-adversarial process, we go through a screening process where each of the parties is being interviewed thoroughly to identify those frailties and those areas that may establish this so-called imbalance of power. Let us not forget, though, that once a party is represented by a lawyer, that takes away a lot of the imbalance. That lawyer's role is now to protect the interest of his client when it comes into a mediation process or even into a collaborative process. At the end of the day, that a concern is truly evident in self-represented parties that jump into or want to go to mediation or a or the other non-adversarial approaches. And this is where the mediator may have some issues there and need some protection in place to make sure that this is not the case. But that's what I find, that if that's the hurdle for many of our colleagues, then that should not be a concern, considering the process that we have in place to ensure that this power imbalance is not dominant in the process, and that the parties can actually achieve a resolution that is respectful, and that they are they rule over their own destiny. That is the point of the matter here, as opposed to letting somebody else make the decision for them. And obviously, there are those who suffered perhaps domestic violence or other emotional abuse. But when we step into the process as lawyers protecting that client, it's, in my view, we are in the same shoes as if we were going to the adversarial model and advocating for our client and why there should be a different type of resolution, etc. But I believe that the non-adversarial also promote the healing, even for that person who might have suffered some emotional distress during the relationship, or feels that they are not the dominant, or that they cannot face their spouse in the process. So that's the reason that I agree with Melissa that the role of lawyers is not diminished. If anything, it's enhanced in that respect when they come to represent their client in a mediation or in a collaborative process. They definitely have that important role to play to ensure the disclosure, to ensure the ability of their client to make a free and voluntary decision, understanding what are the or whether there are any influences outside of the relationship between the client and the lawyer whether there's communication from other family members, adult children, and other that may influence a party's position in a mediation that may not seem reasonable or in line with the principles that we're still trying to bring to the table when we try to resolve a matter in a non-adversarial model. We're still applying the same principles that would have been employed or that would have been coerced or compelled on parties in the adversarial model. Only that we're trying to do that within the range in a way that that both parties can live with. So that's my comment on this major hurdle of the power imbalance. I don't remember the second one there. I'll leave that to Melissa if she wants to add more.
Sure. Yeah. So I think the second one that came across was the full disclosure risk. And, certainly that is a risk no matter what process that you are in. I mean, how many of us have been in chambers trying to get disclosure orders that were, not followed, and then now you've got breaches of everything, right? So that's a risk no matter what kind of forum you're in. But as kind of an outlier, because, I, as the one lawyer, I am the lawyer for the family. And so the identifiable risks of that power imbalance was something that the Law Society of Alberta, through the series of applications that I was making with them in order to have the waiver that allows me to represent the couples together, that was a really significant piece that we were designing. And to Golan's point, it all comes into the intake process. And there are identifiable markers for any experienced family counsel in terms of, okay, are these people suitable first to self-advocate? Because that is a big part of our process and what most people now are wanting to choose for themselves. But also, is this a risk that they could, by having one who has perhaps a more forceful personality, or maybe they have more understanding of the finances, different things that would kind of measure that level of, okay, are they suitable for this? Or would this power imbalance mean that they need their own advocates? In which case, then the collaborative process is more suitable to them. The mediation process, where someone is there to kind of mediate differences, would be a more suitable option. So I would say, the intake part, to Golan's point, is a really important piece to any of us who are screening for power imbalances and where we can kind of place these clients within the process.
Interesting. Very nice to know, Melissa and Golan. Thank you. But I do have one question just to follow up on that. So, in case you find that there is something which is kind of not conducive to this collaborative process, and you do have those power imbalances flags that you're able to kind of identify it early on in the intake process, do you have any tips and tricks how to handle it? And then how do you navigate that if you do see those red flags?
So in our process in particular, that would be referring either clients out for independent legal advice to kind of assist them with, if this is a situation where within the process that's identified, then that is something that is kind of, we halt the process for a bit, have them seek independent counsel, get that information on that one-sided piece. But I can't speak to kind of the more traditional ways. I think, Golan, that would be more up to you. But in our process, it really is like it's through the screening. There is an interview process as well. And then, like I said, throughout the whole intake form that they fill out, from that point, there are specific markers. I mean, some are pretty self-evident. We do ask them whether they consider themselves amicable, whether there's a history of family violence. So those would really preclude participants from our particular method. But certainly sometimes, even when I see age differences, and that could be a risk marker, is there a power imbalance there because one may have more sophisticated understanding of certain things, but that's not a precursor necessarily. It just means that counsel needs to dive in a little bit deeper into, okay, actually, you know what? I've been running this business alongside my partner. I have a full understanding of how all of this works. And so that may be a precursor to a potential power imbalance, but may not preclude them from still, again, being able to advocate for themselves throughout a process.
Okay. Thank you, Melissa. And if my understanding is correct, sorry, Golan, you were saying.
No, firstly, I definitely agree with Melissa here. But I wanted to add that when we do see this power imbalance, again, it depends on the level of the imbalance that we're talking about and whether there could be some protections in place to minimize that and to basically allow this process to still work. If that's what the parties conscientiously and with informed decision making that as their choice. But in the event that it's not something that we as professional mediators or a one lawyer, a advocate trying to assist the family, see that this is not something that's going to be workable, or it's not going to end up in a something reasonable or fair to the parties, then perhaps there is no other option but the adversarial system, and they each have to go and get their own independent legal advisor to assist them in the process, and they may end up in court after all, and and that may be the ultimate protection, if you will, in terms of looking after the what's the appropriate order or resolution that should be imposed as opposed to agreed on between the parties.
Thank you, Golan. And what I understand from both of you is that while there is a shift in the market dynamics when it comes to a more collaborative model, the adversarial model still exists. And the precursor to this would be that the parties have to self-identify themselves as being committed to this process, because if they don't, then the adversarial process is the way to go for them. And that kind of brings us to our next question, the next topic, which is why adversarial model remains the default, and why does our legal process default to adversarial framing even when conflict is not present. So for example, like what institutional ethical liability pressures shape the lawyer's choices then? I think, Golan, this is a topic that you've kind of already covered in a little bit, like in quite a bit so
I can
far,
add
but
it.
if you could just add in case we've missed out anything while we're discussing this.
Yes, thank you for that, Deepti. What I was thinking is just in terms of historical reasons, the adversarial system has always been there. That was the way that the justice system had been designed for centuries. So think about courts in the common law system and how they looking at a pulling out the truth through cross-examination, and that adversarial process still remains till today. The understanding of how that process affect the parties is what drove or have that cultural shift in a way to the more less adversarial process of mediation or collaborative process. And just by the way, maybe I digress for a second. Dipti, you mentioned how parties are showing commitment to a process of collaborative practice. It's not only the parties, it's also the lawyers who are going to be representing their or going to be involved in the process that are committed to the process by one of the major thing is their agreement to not go to court, and that takes away that threat, if you wish, that if you don't get what I am trying to get to, will jump into the court system and abandon the collaborative process. The idea is to really hammer things out until white smoke comes out to get the resolution that we need, knowing that no one can go to court, at least the lawyers cannot go to court in this process, and they will need to be removed from the case if the parties or one of the parties decides to abandon the case. Back to the structural and historical reasons for the adversarial system. One of the concepts around it is the perception of fairness, when parties can put in their best case forward, can challenge the other side's evidence. They can be represented by counsel who would be advocating solely and only in their best interest. That is often looked at as the safeguard against the state overreaching and making decisions that are not in line with the best interest of a party. And let's not forget, even today, when you go to university, that's what you train to do. You train to frame your dispute, to advocate position, to cross-examine. The idea of a win and lose is in the heart of the profession still. So your client wants to feel, did I win or did I lose that motion? So it's that concept is still there, and it's not always a helpful to shift that it's a cultural change that is needed to understand that, the fact that I win and the other side lost, really maybe the family or the children lost at the end of the day here. So when you're shifting the focus on the family and the best interest of the children and something around the concept of what would be fair and reasonable in circumstances, that is what's required to make the change. Now, in addition to that, in the adversarial system, don't forget that we have that procedural predictability. That was something that is embedded in the process, even though it might take a long time. The delays could be an institutional delay or a tactical delay by one of the parties, the counsel or self-rep. But think about the procedural predictability in terms of, I know what's the next event. I know that I can bring a motion forward. I know the next hearing, whether it's a case conference, settlement conference, pretrial conference, all of these exhausting procedural steps. But nevertheless, it's kind of predictable and we know where the case is heading. So that helps maintain that idea of the adversarial system being relevant today. Don't forget that the judiciary as well, they train exactly in the same way. The adversarial reasoning, who's advocating in a more convincing way that caused them to be more analytical of their judgments or their decision. At the end of the day, they are bound by precedents. Those precedents came out of either a trial or a motion or other decisions that they had to deal with. So it's all embedded in this adversarial system that at the end of the day, the assumption persists. And that's the reason that we still have it. Although I tend to agree with Melissa and with you, Deepti, that there is a shift, but I think it's the question is what's the motivation for the shift, and it's not necessarily taking away from the advantages of the adversarial system in terms of predictability and really getting the truth out through cross-examination and evidentiary issues. But there are definitely other reasons that the separating spouses today have to consider, including the well-being of the children themselves, the financial well-being of this family before it falls apart and spend all of its wealth on the legal system.
Thank you, Golan. And just to add to that, I would say that still, as the statistics do reflect, and I'm not just talking about family law in that context, but in terms of all the civil litigation cases, 95% of them are still getting settled out of court, and only 5% of them are going through litigation and court process. So I think there is a huge, huge gap that the lawyers, with the change in their approach towards a collaborative process, can kind of fill the gap in the market, because like it's right there, 95% of them are getting resolved through settlement and out of court negotiations. But thank you so much. And I think, Golan, the next topic also again talks about the assumptions that are persisting in the adversarial process. And I can read out the topic to you if that helps, Golan.
Are we talking about
Third
who that
topic.
process does not serve, right?
Yeah.
Right. So we spoke about the adversarial system. We spoke about the presumption of that conflict is either black or white. There's going to be a decision one way or another. You basically position parties in a battle position to as competitors and not as collaborators in their family dispute. and then that the reasonableness must be demonstrated through their evidentiary battle. And this presumption do not help families and children specifically, because it serves to intensify the conflict. It is discouraging communication that can help resolve issues, whether it's in the parenting situation or even in the financial aspect. It intensifies the negative approaches of each of the parents. It really is almost like you instilling more of a bad atmosphere to the already tense situation that the parties have started with when they decided to separate. So it's just you're adding more fuel to the fire in a sense, and it's a never-ending conflict. And then when you create a winner-loser dynamic, it's not helping the family. When you're looking at self-represented litigants, for example, that adversarial system is not, I'm not talking about those that are truly sophisticated in a way that they can use and understand the procedure of the court and able to advocate for themselves. But most self-represented are always overwhelmed with the procedural requirements, the evidentiary rules, the high emotional stakes that comes with the a fight in court. And you can see, I was in court many times with seeing self-represented going at it, and you can see the emotional toll. You can see the crying. You can see the breakdowns. It's there. It happens time and again, and that's where the adversarial system does not serve them well. We spoke about the power imbalance. Even though we are looking to the court, the adversarial system, to protect those litigants with power imbalance, it doesn't necessarily wipe out the balance, because if there is economic disparity and one is able to afford the legal process better than the other, or when you have language barriers, or where you have a historical domestic and intimidation going on, or one of the parties is suffering from mental health vulnerability, all of these factors cannot be served well in the adversarial system, in my respectful submissions here. And when we look at the justice system itself, I don't think the adversarial litigation helping our system to be more efficient. In fact, the process is expensive. We know it's slow. We've been there. Some cases have been taking years. And that's the reason sometimes, Deepti, you mentioned that statistically, many end up with a resolution outside of court. That may be one of the reasons that it happens, because people are burnt out. People are out of money, might have already realized the impact on the children after a few years of battling in the courthouse, and maybe have matured up. A lot of things have to do with time is the best cure. I say that many times. We know that as time goes by, things settle down most times better. And that's the reason I'm thinking that even for the justice system, if the justice system does not encourage the settlement, and nowadays even the judges and the judicial system is those who are more proactive would encourage parties to settle or give opinion on matters, such that the parties can go out and make their recommendations to their client based on opinions from the bench, and now that they can rely on, and the parties have heard it from the judge. So in a way, sometimes you need the party to feel that they had their day in court, and that's an important aspect of the adversarial system. On the other hand, the justice system is able to drive the parties to a settlement if they are more proactive, and that's the reason we have these built-in settlement conferences and other conferences that exhausting the parties as they go through the process. But at the end of the day, you can avoid all of that if you jump straight to a more amicable process like Melissa is offering, the one lawyer system that we have. That's I understand in Alberta. In Ontario, you have to remember, and I'm sure that in Alberta as well, but the issue of um, the conflict of interest has to be always on the lawyer's mind when he's looking after assisting self litigants in try to resolve family matters for the family. But the issue of confidentiality, the idea of looking at one's interest and not opposing the other. So all of these things have to be taken into account. And that's the reason that we have the idea of, for example, when I do mediation, I always encourage that the mediation would be with lawyers, and that's the best protection also for us as mediator, or when we go into collaborative practice, when the other parties are protected or have their own representation, when they come to mediation, it is a more suitable environment that also takes away that idea of, or at least minimize the power imbalance that many practitioners have indicated being a block in their approach towards that method. That's my comments on that topic, Deepti, and if Melissa wants to add anything else, of course.
Yeah, I think, what you were just talking about is again like the shifting landscape of the law and how, we have continuously been meeting the needs of, the changing social landscape. And I think, overall the application that I made and the reason why I have a waiver is our code of conduct here in Alberta does state that it is a conflict of interest for a lawyer to represent opposing parties in an active dispute. And what I started to argue is I don't think every family, every divorcing couple views themselves as opposing interests. Certainly, most of the co-parents that I'm assisting do not. They're like, we have as many reasons to have shared interests as possible in all of this, nor do they view themselves as being in an active dispute. And I think the law still presumes in the adversarial process that you are in an active dispute. We still are having to sue for divorce, different things like that. But clients have changed now where they're like, we actually want a more cooperative kind of process. And I think the evolution and, we welcomed the collaborative movement that came through a few decades ago, and how strong mediation has been, to Deepti's point. And then this is just a natural extension of, can we change our minds to the fact that not all clients are in a dispute? Do they need legal information? Absolutely. Do they need legal guidance and assistance? Absolutely as well. And that's what they're seeking, right? But are we able to do that through a more neutral lens, right? A shared family lawyer that delivers neutral, impartial legal information to them. They have the full disclosure, they have all of the steps that they are taking, and then they themselves are the ones that are creating the terms of settlement, but from an informed perspective, from a place that they understand the law as it applies to them, and then they are actually the ones in the driver's seat. And I think just that code provision of, once, the Law Society and I went back and forth on this, it's true that not everybody, to your point, Golan, of like having to discovery and all of these other things that we used to have to do, that's not actually the process anymore that most of us are doing, even in the collaborative process, right? So this is, again, not everybody is viewed to be in an active dispute, and how can we meet the needs of those ones who don't presuppose that in their own legal divorces or separations. Yeah. So Deepti, I'm not sure, where we are. I understand there's, I see that there's questions in the chat as well. We've got about 15 minutes left here. If we want to just kind of dive into the one lawyer method a little bit more, or whether you had kind of some other pieces that you wanted to weigh in on. No? Oh, I think you're muted. Oh, you're muted, Deepti.
My apologies.
Yep.
So I was just saying that in the interest of time, I will just quickly bring one more thing to the attention while we are at this topic. The fact that the non-adversarial pathways are expanding and the courts are also recognizing, and it is in the form of the recent family-focused protocol approach that Alberta has kind of put in place. They have made mediation, negotiation, settlement, alternate dispute resolution as the front door of the courthouse, which again reflects that there is a tectonic shift in the way the market is kind of demanding this kind of an approach from the legal system, and the legal system is kind of catering to their demands and their needs. So I think there is definitely a tectonic shift in that direction. Have we completely moved to a non-adversarial system? No. However, there is a shift, there is a considerable shift, there is a considerable demand for non-adversarial pathways. And at the same time, when the parties are reaching an impasse, then obviously the adversarial way is the way to go. I would leave the floor open to you, Melissa, to talk about the one lawyer method.
Yeah. Okay. Thank you, Deepti. And that is the market-driven approach. I really like that. It's, meeting the needs of the clients that we have and, how everything is changing. And so, essentially for me, this is, the one lawyer concept, I understand is very radical. It was even to me when I found it a few years ago. And so, I found myself from a litigation practice of evolving into collaborative mediation. But what I still found was a disconnect where many people who just literally wanted to work together, they weren't fighting each other. They had, a lot of this is already sorted out. We just want to confirm that we're in alignment with the law. And so I was really looking for some alternatives as to how I could assist them with that within the confines of our current kind of formal professional duties. And, of course, to represent one, to help them draft the terms of settlement, then you need to send the other one to independent legal advice. Are we actually then serving joint shared interests? Those types of things. And then I found myself traveling and came across this concept of one neutral, impartial family lawyer delivering joint legal advice to a couple who retains them together. And that I found in the UK and Wales. And it was really this aha moment for me, understanding that, of course, here in Canada, our common law, flows from the UK. So certainly if they're, approaching it this way, then there must be a need for that and it must be working. And so from that point, my journey took me from this great idea that seemed very radical and impossible here in Canada. I thought, well, this is kind of a thing that, are we able to adopt this? Are we able to having the great fortune of, practicing in a jurisdiction that has what we call an innovation sandbox. So the Law Society of Alberta is recognizing the changing needs of clients. It's still their duty to kind of make sure that any, new service deliveries that may be harmful to the public are done and created in a very safe regulatory space. So the innovation sandbox allows a certain amount of relaxation of certain code provisions for us practitioners. But again, the regulation group carefully monitors this to monitor risk. So I made my first petition to the Law Society of Alberta for an application to dispense, to get a waiver of this code of conduct provision, arguing again that not all clients are opposing parties in an active dispute. That took me over 2 years with the Law Society of Alberta, lots and lots of back and forth, lots of case studies, lots of calls and phone chats with my colleagues over in London, kind of what were they doing, how were they delivering this service. But then through kind of all of this application process, the Law Society then granted us an 18-month pilot project. And that's really where we started to create our process. The one lawyer divorce method is a streamlined 7-step process that we deliver to clients from start to finish together. It starts with an intake and then there's a series of different steps. Clients understand this process from the get-go. They are participants in our particular model, so they do sign a participation kind of agreement and waiver stating that they are not opposing parties or in an active dispute. Very simplifying this, I understand, for the balance of time. It's not quite that simple, but there's a whole rigorous process as to whether they are going to be capable of pursuing this method and then from there. But really what it is it marks a shift in the clients who are wanting a shared experience, but they want a shared family lawyer that they know is not going to have one zealous advocate on one side and one on the other. That is kind of the thing. And again, mediation presupposes that there's some, disputes in there. And what I found was that so many of them wanted information, but they had disagreements. Of course, there's reasons why, people do legally separate. However, they are not in a dispute. They're, to Golan's point that you made earlier, they understand that at the cost of the other, the outcome for them of getting more than what, perhaps they should from a rights-based approach is not beneficial to their family as a whole. And I think what this really is a reflection of changing dynamics of families. Lots of people have been through divorces themselves as children, and so they understand the risks involved. They do want to prioritize healthy relationships with one another. They understand that they can recreate their relationship from husband and wife to just being the most amazing co-parents, mom and dad, those types of things. So our method is not for everyone. We are very open and honest about that. There are certainly, some people that just do need advocates on each side. But what we are doing here with our approach is, again, identifying those amicable couples, taking them out of the formal legal system, giving them the information, and then they're the ones that are deciding. And then as the neutral lawyer, I'm there to facilitate the kind of formalization of those agreements through a very safe space. So, for us, the beautiful part is that the Law Society of Alberta, after our pilot, there's lots of reporting requirements, different things about our clients, how it's been going. They've now provided us the waiver in an unlimited capacity. So what this means is that we are able to, expand this beyond kind of, just our particular practice, but using the 7-step process. Some of it's streamlined even, there's 4 steps for some people and a few more steps for the complexities. But what this marks is just a shift. Another one from the beautiful collaborative movement to, again, a neutral shared family lawyer. So our process itself for the benefits for clients, of course, costs, as Golan referred to. So because we do have a closed process, we're able to offer this flat fee to our clients. Most of them are completed their process from between 4 to 6 weeks, because again, we're not waiting on other lawyers' timelines. We're not waiting on, everything is provided ahead of time. They fill out a whole series of forms for us, including their disclosure forms that, again, comply with, to your point, Deepti, if this did not work out for them and they ended up in this court system, they have all of their disclosure prepared. It's an ADR process that they have participated in. So really low risks for them, even from a financial perspective. But again, it's just a kinder, a softer way. And now having gone through, we've successfully achieved this through 222 couples so far, have participated through our method and have been successful through this. And again, we send the court orders. The judges are reviewing all of this from a joint perspective. But again, it's just not for everybody, but for the people that it is for, it's working brilliantly, and it's a pleasure to serve them.
Firstly, Melissa, it's a very interesting and kudos for you for being persistent with the Law Society. We know how rigid they can be in terms of shifting from one method to another.
Yeah.
I don't think Ontario is there yet, because we still require the other party to obtain independent legal advice if we were to assist parties in, say, we have an agreement and we agree on the terms, just produce a separation agreement for us. At the end of the day, the lawyer has responsibility and is operating under very strict professional conduct boundaries. I was just wondering, in Alberta, you said that it was an 18-month process. How far are you into it? Are you done with that?
Yeah, so we're past the pilot project stage now. So in 2023, we received one family law, then received an unlimited auto renewal. Of course, we are still, because we're so innovative and different, we report to the Law Society. The Law Society continues to regulate our practice very carefully. But one family law is now able to kind of extend this beyond just our own kind of process, because again, it's the method itself, and it's the mindset shift from independent legal advice to impartial legal advice. And are we ready as a shift? And that could be a whole other podcast, and probably many academic articles need to be written on that. But really, is one specially trained neutral family lawyer able to dispense impartial legal advice in this way where it empowers the clients to have the information? Because it's their neutral lawyer, I'm here for the family. So I'm here to look at whether you are, what ages you're at, what ages your kids are at, assess really what your acute needs are. And within the 7 steps, we provide provide our clients parenting plan templates, booklets. We walk them through the Section 7 expenses to make sure they have a foundation for that. Do they understand how they're going to do their child support review every year because they're sharing their parenting? So, a lot of those things are what we found that clients are finding on ChatGPT, but we're able as counsel to kind of fill those gaps for them. And then again, to formalize those documents. So I think like it's just kind of that shift in that mindset of like, can I put my hat on as an impartial where I'm here as the lawyer for the family? And that really was when it started to click for me. Like, I'm not here for one or the other. I'm here for you, and everybody else, right? Dogs, cats, everybody involved. We have them involved in the process.
Very interesting.
So I think we have a note here. I'm sorry, I'm just going to, yeah. So I think we've only got a few more minutes left, so I don't want to kind of take up everybody else's space. But I think, again, what we're hoping to do is kind of, continue to do our worthy work here in the legal landscape, but just knowing that, thankfully, in accordance with the Law Society, we are here to stay, and just seeing other jurisdictions do this and doing it successfully, I think should challenge us Canadian lawyers that it actually is possible.
Thank you so much, Melissa. And I guess it's not just 222 couples that you've kind of helped, but it's the 223 couples, and the last one being you and the Law Society.
Oh, that's a lovely way to do it. Yeah. And again, this was a labor of all of us involved. The Law Society was keenly involved in this as well, because they recognize that, in the judiciary here as well, the more that we can keep these amicable couples away from, the need to access the court system, that frees up resources for those who actually, again, to my very point, some people do need that system, but many of them do not. But the risks that we were finding was those are the people who are trying to find paralegals to draft documents for them, or incomplete legal, they're not getting legal advice. And with that, then the risks have increased to them that later on they didn't know perhaps that their pension had not been, decided upon. And now you've left that open, right? So that's where your neutral professional kind of expert family lawyer can help guide those people. So yeah, thank you.
Yeah. I think after 16 years of marriage and 2 children, I don't think me and my husband are going anywhere, but if we have to, I'm coming to you.
Oh, well, that's very kind. Thank you. Okay. All right. So
I guess you're in Jen's hand how to take this forward, because we're kind of
I
inching
think there are
closer.
there's a few questions, I think.
So do
Yes.
we take those? I think more or less we've kind of addressed all 10, but I just leave it open to Jen to kind of direct us. We're in your hands, Jen.
Sure. We're going to pivot to audience questions now. So our first question for the panelists, how does this differ from mediation with a lawyer mediator?
Okay, so I think that one's directed kind of more to ours. So again, it's the taking out of the presupposition of active dispute and opposing parties. So that's still really embedded in the mediative approach right now. And then again, because a mediator lawyer cannot formalize documents, cannot provide legal advice to formalize everything, we are in a position that we can do that, subject to, certain different ways that we approach that, that's based on the Law Society's regulation.
Great. Our second audience question, how do you navigate a conflict of interest with this?
So I guess the starting point again, and to Golan's point, is self-selection. So we do, our clients are self-selecting to be in this one lawyer process. So that's the starting point. We do, again, after the screening process, and I've kind of approved them that I think that they're suitable for this, they sign a specific waiver that we've developed. So again, just kind of understanding that there is this code provision that states that it's a conflict of interest if they are opposing active dispute. They understand the differences between that, and then they self-select into that. So that was a particular part of our methodology that we developed with the Law Society.
Our next question, can one lawyer represent both parties in joint divorce when one party is in another province, provided that there is no conflict of interest?
Oh, good question. I don't know how far that goes. I think given that we can apply for a joint divorce judgment here in Alberta if only one spouse resides here, I would consider likely that would be something that we could do. It's just never come up for me just yet. I have plenty of clients from top to bottom Alberta, but no one has of yet. I mean, lots of people have reached out as to whether they could have me represent them in BC, but as of yet, we're working on that, but just we're not there yet.
I
Okay.
have to say that this is an interesting question, but because a lawyer in one province not necessarily aware of the rules
That's the
and
piece.
regulations of another law society, I would I would stay out of that situation.
I
Perhaps act as an agent just to prepare
Yeah,
the joint divorce, not provide the lawyer's certificate within the joint divorce
yeah,
application. That I think that would be the safest bet because
I
I,
agree.
I don't know what's going on in British Columbia, for example, in
That's the
that case.
thing.
I did not even know the Alberta one lawyer approach until I heard it from Melissa today. So that's an excellent point. But to our lawyers out there, I think you have to really familiar yourself with the province's regulations at the time, right?
All right, our next question. Do you see the use of DRO program as a shift from the courts towards a less adversarial process?
I can take that for a moment. I think it is in a sense. I mean, the idea of firstly, it's called dispute resolution officer. The idea is
Right.
really to target that as a resolution a method, and it was for the sake of uh, getting parties before into the court system in a more timely fashion and still perhaps be able to resolve those matters that do not necessarily require the justice system to be fully involved and moving it before a justice. Um, a DRO can definitely see whether the parties before him are able to move or narrow down the issues between them. So it is, in my view, a shift towards that, but it's there really to help the judiciary to navigate all these cases that are jumping into court and need attention and kind of instead of having case conferences all the time, perhaps that's another way of moving cases along. But again, it depends on the personality of the DRO, whether they're proactive there, whether they're willing to give an opinion or engage with the parties in such a way that can drive them outside of the courthouse and cause them to reach a resolution. Yeah.
All right. Our next question. While mediators are trained and obliged to complete IPV screening/assessments, how does a lawyer do this? Do they have a professional complete the screening and assessment for both parties?
I can probably just add a few things, and I would obviously like to hear from the expert and the legends here. But I can definitely say that it's high time that we stop looking into the rear view mirror and say how it was practiced in the past, but kind of move along, cater to what the client needs now. And historically, it's not that the entire process has all the negatives and no positives for us to take away. So we have been referring clients to counseling, to other sources where they can be directed to those experts to handle a certain thing. There is definitely a skill gap, I would say, because the lawyers have so far been trained into the act of war. So
Mm.
it's always been cross-examination, persuasive writing. So it definitely needs a shift where art of peace needs to be practiced. There has to be an interest-based negotiation and psychological mentoring, which is a skill gap which needs to be addressed for future. And having said that, like mediators got trained for IPV screening, maybe in future the lawyers need to get some kind of training and some kind of tools that they can have in their toolkit when we're addressing these sophisticated and sensitive issues with clients.
Any comment from anybody else? That's okay.
I can add to that
Sure.
directly to the question, if a mediator is acting for two self-reps, yes, he's obligated to do the screening process with each of them separately. That's the reason that most certified mediators, all certified mediators, will go through that training of what to look for during the screening. There's almost like a whole checks that you have to cover to ensure that you covered all these areas of concern, whether it's mental health, whether it's violence, whether it's weapons and what triggers the parties, etc. all of these things have to come to the surface when you taking on this screening of self represented who comes to see you as a mediator. If they're represented by counsel, you can assume that their counsel went through that with them, and that's kind of take away the burden from the mediator. But that's my comment on that.
All right, and moving on to our next question. How are you providing legal advice to the different parties? I am thinking of a situation where one party is seeking spousal support and the other does not believe that there is an entitlement to spousal support. Are you providing the legal advice and explaining the different positions on the issue?
Yeah, absolutely. So part of our process is, after the intake is completed and the lawyer then assesses all of the issues, and spousal support is, if there's a discrepancy in their incomes, then that is something that needs to be explained. We then explain that through a legal opinion, and that sets out how the law works, what spousal support is, and the reasons why it's payable here in Canada, the different forms it takes, and how it applies to them. And again, a lot of this is there's maybe a reticence to pay spousal support at the very beginning because it's not understood the whole reasons why. But when you understand that your co-parent is going to require this in order to provide your children with equalized standards of living, then that tends to go a little bit differently. So again, it comes through the legal opinion where the legal information is provided to the clients. And then from there, usually any kind of differences of opinions are ones bridges that they gap.
Great. Our next question. Under the Divorce Act, lawyers have a duty to encourage clients to try a family dispute resolution process. Do you think that this has promoted the shift towards out-of-court dispute resolution?
Absolutely. I've based my entire philosophy on it. Yeah.
Yeah, I think both the processes are taking feedback from each other. So it's not just because the court's kind of mandating it that the parties have now started to accept it. It's probably the other way, where the courts have seen the gap in the legal process and they're trying to kind of bridge that gap. And we all have to agree that the collaborative model is only successful when the clients are treating the divorce as a problem to be solved and not as a war that needs to be won. So until and unless they have that kind of mindset, the collaborative process or the one lawyer divorce probably is not going to be successful, and the adversarial way is the way to go.
All right, and our last question now. How can I learn more about the 7-step process?
So our website is onefamily.law. So that explains to prospective clients as well as other lawyers. As I said, it has been kind of, a big kind of process that we've been going. So we are getting insights and information and interest from practitioners across Canada. So if you're interested in more, just reach out through our website. And we're always happy to have discussions as to how we can expand this movement forward.
All right, well, that concludes today's session. So thank you to all our panelists for donating their time and sharing their knowledge today. All the resources mentioned today will be included in the show notes, which you will receive an email for later this week. So thank you for joining and participating in Family Law Now, and that concludes today's session.
Thank you, Jen. Thank you,
you,
Melissa
Jen.
and Deepti.